Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Happy Wednesday to you. Hope you're geared up to have a great day. This is going to be a 2-episode day for me. I started this episode last night, but 40 minutes into it, my internet decided it was time for a nap, which was frustrating. I invented a few curse words of my own and then went to bed. So we're going to try this again. We're going to jump right into this. There's a lot to cover with the filings by the state and the clerk of court, Becky Hill, and the Alex Murdaugh case, where he's asking for a new trial based on jury tampering. Music fact of the day, the great song The Chain by Fleetwood Mac. It was actually going to be a throwaway song because it really did not have a straight narrative. However, Stevie Nicks came up with the line, "The chain will keep us together." Later on, Mick Fleetwood said that line ended up becoming a prayer, that the band would not fall apart after recording the breakthrough amazing album Rumors. If you're watching on YouTube, please subscribe, hit the like button, share the video, hit that bell notification. It's a really simple way to support this podcast. This is the first time we've heard from Becky Hill since all of this came to light a couple of months ago. I adore Miss Hill. She is as sweet as pie. She is your typical Southern belle sweetheart. I'm also a fan of letting the judicial process work. You guys know I interviewed her a few months ago here on the podcast. We went to dinner after, had a wonderful time, and actually didn't talk about the case much at all. Past being relieved it was over, and here we are again. Let's go through what her response is. The affidavit was submitted at the request of the South Carolina Attorney General to address the allegations of jury tampering and an Alex motion for a new trial. He filed that October 27th. She says there are numerous misrepresentations and false statements contained within the motion for a new trial to which I was not requested to specifically address. As such, this affidavit is not intended to address every single allegation contained in the motion for a new trial. After being elected in 2020, I have served as the clerk of court in Colleton County. I was the elected clerk of court for Colleton County during the case of the state of South Carolina versus Richard Alex Murdaugh. I've reviewed Mr. Murdaugh's motion for a new trial. As to the allegations contained in the affidavit for juror number 630, I did not tell the jury to be fooled by evidence presented by Mr. Murdaugh's attorney. I did not instruct the jury to watch him closely, to watch his movements. I did not say to the jury, this shouldn't take us long. When juror 826 asked to speak with me, the conversation took place in the jury room hall within earshot of bailiff Bill Polk. The conversations did not involve the evidence, witnesses, or substance of the trial. As to the allegations within the affidavit of Holly Miller, that is Dick Harpootlian's paralegal, discussing an alleged conversation with juror 741. I did not have private conversations with juror 826 in the bathroom. My conversation with juror 826 did not involve the evidence, witnesses, or substance of the trial. During the trial, I did not tell members of the jury that the media would want to interview them at the end of the trial. During the trial, I did not hand out business cards to media personnel. I didn't get one, just saying. I did not tell jurors, y'all are going to hear things that will throw you all off. Don't let this distract or mislead you. As to the allegations within the affidavit of juror 785, I did not tell the jurors not to be fooled by the evidence presented by Alex Murdaugh's attorneys. I did not ask juror 785 whether that juror was inclined to vote guilty or not guilty. I did not tell juror 785 that SLED and Colleton County Sheriff's Office personnel went to her ex-husband's house. I did not tell juror 785 that I would reinstate a restraining order against her ex-husband. I did not state to that juror that Murdaugh probably got to him, meaning I believe the ex-husband. I did not ask juror 785 about her opinions regarding Mr. Murdaugh's guilt. I did not ask, well, what makes you think he's guilty? I did not discuss the evidence presented at trial with juror 785. I did not tell the juror that everything Mr. Murdaugh had said were lies. I did not tell juror 785 to forget about the guns. They will never be seen again. I did not ask the juror about the views of the rest of the jury. I did not tell juror 785 if the foreperson would just go in and ask for a raise of hands, this would be over and done with. I did not inform juror 785 that everyone needs to be on the same page. I did not fabricate nor did I create any Facebook post related to Juror 785. If you remember, there was an allegation that there was a post by the ex-husband that Juror 785 had been discussing the case. As to the allegations within the affidavit of Holly Miller discussing an alleged conversation with Juror 326, I did not tell jurors they were prohibited from taking a smoke break during deliberations, and that was the end of her affidavit. The state filed their response to Alex's motion for a new trial, and also they filed a state's motion to strike. By the way, the transcript for this trial, 5,895 pages. God bless whoever had to put that together. In the beginning of the filing, they go through just a summary of the case, his conviction, and his sentencing. Then we get into the meat of their argument. I'm not going to read this word for word, and I'm not going to cite every case that they quote from. I will post a link to this document so you guys can look over it for yourself if you want to look up any of the cases that they cite in their filing. It says Murdaugh broadly claims that he is entitled to a new trial based upon allegations that the clerk of court of Colleton County, Becky Hill, improperly attempted to influence the jury's decision. In support of his claim, Murdaugh offers affidavits from one juror who participated in deliberations, one who was moved for dishonesty, concealing her own improper communications about the case, and two hearsay affidavits from his counsel's paralegal. Murdaugh additionally advances a sweeping conspiracy theory about wholly irrelevant Facebook posts with scant evidence to support it. The state responds as follows. Law and procedure. The law permits but skeptically receives motions for new trials based on after discovered evidence, and never does the law permit highly motivated convicts to put their own jury on trial. There can be no doubt that motions of this sort should be received with the utmost caution because, as it is said by a learned judge, there are but few cases tried in which something new may not be hunted up, and also because it tends to perjury. It would have a mischievous tendency after all the evidence on the part of the state have been fully disclosed to allow one with his life in danger an opportunity by the assistance of Confederates to procure unprincipled witnesses to contradict the evidence on the part of the state and thereby defeat the ends of justice. Nonetheless, criminal defendants have a right to a fair and impartial jury, and private communications or contact with jurors during a criminal trial about the matter pending before them may necessitate an evidentiary hearing, and if the defendant can show actual prejudice, a new trial. The court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has an opportunity to prove actual bias. They're quoting State versus Green in that one. And in that, they unanimously declined to adopt Rimmer versus the United States and its presumptive prejudice standard in every instance of improper contact, and reversing the lower court opinion that did so. Not every inappropriate comment by a member of court staff to a juror rises to the level of constitutional error. That's from a South Carolina case called Green. And also State versus Cameron. Were that the rule, few trials would be constitutionally acceptable. Additionally, jurors are presumed to follow law as instructed to them to include instructions of what constitutes proper evidence to consider in deliberations, and such instructions are usually deemed to have cured the erroneous exposure to improper evidence or argument. Where a defendant knows or could have known of a constitutional issue at the time of trial, the defendant is obliged to timely raise that issue to the court's attention or else waive it on future appeals. To whatever extent Murdaugh may insist Rimmer as controlling, federal courts are hardly consistent in interpreting and applying it. Compare the United States versus Frost, holding that not all communications with jurors warrant a hearing and that the defendant must show that unauthorized contact created actual juror bias. If a defendant makes a threshold showing of a credible allegation that unauthorized juror contact was made, they are entitled to a rebuttal presumption of prejudice and an evidentiary hearing to determine what actually transpired and whether what actually happened was harmless. The U.S. Supreme Court's statement in Smith versus Phillips that defendants must prove actual bias abrogates Rimmer to whatever extent it suggests otherwise. Finally, a significant portion of the Supreme Court of the United States has suggested that Rimmer pronounces no constitutional rule at all. Murdaugh also cites to Cameron, but in that portion of the opinion which does not state the legal standard, but rather quotes a portion of a Fourth Circuit Court of Appeals opinion inconsistent with the standard acknowledged by Cameron and more subsequently clarified in Smith, as most recently in Green. Murdaugh must show both that the alleged improper communications occurred and that jurors were actually biased as a result. And at first, showing that a defendant is entitled to relief is necessary before an evidentiary hearing can be granted. A jury poll may cure any procedural irregularities and confirm that each juror approves of the verdict returned and that no one has been coerced or induced to agree to a verdict to which he or she does not actually assent. If an at first sight showing is made, the resultant evidentiary hearing is a strictly limited, judicially conducted affair, particularly as concerns examinations of the jurors. The competency of jurors as witnesses is strictly circumscribed by the rules of evidence. They go on to say, upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotion as influencing the juror to assent or to dissent from the verdict or indictment or concerning the juror's mental processes in connection therewith, except that a juror may testify on the question whether extraneous prejudicial information was improperly brought to the jury's attention or whether an outside influence was improperly brought to bear upon any juror. Nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes. Murdaugh's motion is filed pursuant to Rule 29B, which pertains to evidence typically conceived as facts which would have been presented to a jury at trial relevant to guilt or innocence, is such as would probably change the result if a new trial was had, has been discovered since the trial, could not by the exercise of due diligence have been discovered before the trial, or is material to the issue of guilt or innocence and is not merely cumulative or impeaching. Generally, juror testimony is not allowed regarding the deliberations of the jury or internal influences. Both the Supreme Court and the Court of Appeals commended the trials court's deft handling in Green for the process it followed in investigating its own allegations of improper communications between a bailiff and a member of the jury. The trial court questioned each juror and the bailiff, which proved there was no reasonable possibility the bailiff's comments influenced the verdict. More specifically, the Honorable Donald B. Hawker, immediately after publishing the verdict, cleared the courtroom of all present save the lawyers involved in the case, the clerk, and the judge's staff, then brought out each juror individually and polled them on the record, asking the following questions with minor variations. Was your verdict guilty on both charges, and is that still your verdict? Was your verdict based 100% on the testimony, evidence, and law presented at this trial? Was your verdict influenced in any manner by any communication with any of the bailiffs or any person outside of the 12-member jury? Did you have any communication with the bailiffs or with a third party not part of the jury? And if so, please relay to the court what those communications were. In State versus Kelly, upon learning that a juror had introduced a religious pamphlet concerning God's view on capital punishment to the rest of the jury, the trial court individually questioned the jurors to determine who, if anyone, had read the pamphlet and what information was contained in the pamphlet. The trial court also conducted the questioning in State versus Bryant using questions submitted by the parties after they learned of improper contact with jurors by an investigator. A little footnote here, it says, in the present case, meaning Murdaugh's, we are now many months, documentaries, and juror interviews removed from the verdict. And so the question of, is that still your verdict, is not one of probative value. Thus, the established practice is when considering allegations of inappropriate communications, the court should question the complaining juror, each juror who engaged in the final deliberations, and the alleged improper communicator, in this case, the clerk, with a mind to at least number one, whether the communication actually occurred and, if so, its context and substance. Number two, the number of jurors exposed to the improper communication. Number three, the weight of the evidence properly before the jury. Number four, the likelihood that the curative measures were effective in reducing the prejudice. The trial court then brought each juror out separately for individual questioning on the record. But for proposed questions submitted and subject to judicial preapproval, the court should not permit interrogation of the jurors by the parties or their attorneys. Jurors are citizens who have committed a tremendous service to their community and country through their sacrifice of time and effort to weigh on the most serious issue that can be put to them, a man's guilt and his freedom. Jury duty is a cornerstone civic duty, and needless exposure of jurors to litigative stress and impeachment by zealous attorneys, particularly in a case with this level of public exposure, can only serve to further discourage citizens from willingly participating in this duty. Near the end of Murdaugh's trial, separately sourced reports of improper discussion and social media posts were brought to the court and investigated, resulting in the excusal of juror 785, who now raises allegations he or she expressly denied to the court when examined. Portions of the trial transcript illuminate or are otherwise relevant to resolving the allegations now raised by Murdaugh. The state excerpts and summarizes them as follows. The court consistently instructed jurors to not discuss the case and to only consider the competent evidence presented in the courtroom. They list a ton of pages within the transcript, and not all, because this transcript is huge, of where the judge told the jury you can't discuss the case with anybody. And then in return, every time we reassembled, he would ask, did anybody try to discuss the case with you? Everybody said no. Nobody ever at one point said yes, whether publicly or privately. It also says in its charge to the jury at the end of the case, the court instructed the jury they were only to accept the evidence presented and that they were the sole judges of credibility. In addition to the dozens of times the court told the jury, do not discuss the case prior to the close of evidence, the court again instructed jurors, if your deliberations necessitate an overnight break, you may use these electronic devices as necessary, but you may not use them to communicate with anyone about the case until the case is over. The court further instructed jurors that an overnight break in deliberations was a possibility, and that if they broke that, they were not to seek information and should avoid the use of electronic devices. Certain statements attributed to Clerk Hill by juror 630 closely resemble statements made in court by the state. The parties made their opening statements on Wednesday, January 25th of 2023. It's crazy to think we're almost a year from when openings started. That was the first time I ever was a correspondent. Kathy Russin, Law and Crime Network, took a big chance on me. And I'm going to tell you, that was a crash course in being a correspondent. I'm always so grateful to Law and Crime Network for trusting me with this case because it was huge. In those opening statements on January 25th of this year, the state, as part of its own opening statements, advised the jury, you're going to see video statements of Alex Murdaugh. You're going to see a body-worn camera of him at the scene when law enforcement arrives and hear what he says about that night. You're going to hear 3 recorded statements on video that he gave with law enforcement, and you're going to hear how things progressed about what he says and what he says he did that night. Watch that closely. Watch his expressions. Listen to what he's saying. Listen to what he's not saying. Use that common sense. Does this seem right, or does something seem a little off? Does something seem a little off about this? The jurors so complied and were closely attentive throughout the trial. At the end of its initial closing arguments, the state implored the jury not to let Murdaugh fool them. They go on to quote closings. This is what he did. This is what he did right here. The defendant, on the other hand, has fooled everyone. Everyone who thought they were close to him, everyone who thought they knew who he was, he's fooled them all. He fooled Maggie and Paul too. They paid for it with their lives. Don't let him fool you too. Later, the state, in its final closing argument, returned to the subject of body language while addressing the testimony of Miss Shelley Smith. That is the caretaker to Miss Libby Murdaugh, which is Alex's mother. As you know, she has advanced Alzheimer's, has 24-hour care. And also on the night of the murders, Alec went to the house. Shelley Smith was there, but the kicker was that Alec said he was there longer than what Miss Shelley Smith testified to. And in fact, he also suggested after the murders a time frame to Shelley that he was at the house. Her testimony was hard to watch. She was very conflicted with the love she has for the family, but also her duty to tell the truth. But in closings, they address Miss Smith's testimony. Do you think she knew right then? And that's real. Shelley is real. You saw her. Body language is so important in life. Mr. Waters was talking about with the defendant all of our body language. Did you see Shelley's? The jurors were not fooled, paid attention to body language, and convicted Murdaugh. The court thoroughly investigated allegations of improper communications by juror 785 and ultimately dismissed the juror for those communications, but gave no weight to the supposed Facebook post reported to the clerk in a conversation which was placed on the record. On Tuesday, February 28th, after the conclusion of the reply examination of Dr. Kenzie, my favorite witness of the whole trial, he's the one that brought to life that crime scene, that murder, how Paul was standing after he had been shot, how Maggie was running towards her baby. The court initiated an in-camera hearing regarding an email that raised juror concerns. In sum and substance, the email represented that the unidentified author heard from an unidentified coworker that said coworker's landlord was a juror who said Murdaugh was innocent, and that said juror works at the monkey farm. No clue what a monkey farm is, y'all. Murdaugh's counsel advised the court to disregard the email as mere noise in a high-profile case, but the state expressed concern about the allegation of a clear violation of the court instructions to the jury and noted there were still alternate jurors. Counsel Griffin speculated without support that the email was an orchestrated effort to get the juror removed. The court then informed the parties of its exchange with Clerk Hill, who had evidently learned of the email. They then go back to the transcript and pull from when this was being addressed. The court, after I showed you all this email, we came back here and the clerk came in and asked whether we had heard the same thing about a juror. And we were all in the midst of trying to figure out who the juror was that this pertained to, since it did not indicate a juror number. It just said someone who worked at the monkey farm. So the clerk then said that she was reading her Facebook messages over the weekend. And then he asked his clerk, did she say over the weekend? The law clerk, she said on Friday she was going through her timeline on Facebook and saw the post from this man who was supposed to be the ex-husband. The court says, yeah, the ex-husband of this juror. And his post was that she was discussing the case with various people. I think that's what Becky said. The law clerk says correct. The court, we asked the clerk to make a copy or get a copy of the Facebook post she was referring to. She came back a little while later and said it had been deleted by this ex-husband and that she brought and printed out what remains on his post, which was him stating that he posted an ugly post, which he deleted. It says in brackets here, substance of a Facebook apology post, humorous exchange between Mr. Metters and Mr. Harpootlian. The court says, but the clerk said that she read the post where he was discussing that his ex-wife, the juror, had been discussing the case. Now, I was just very curious. We were talking about the email and the clerk came in and was talking about a Facebook post. And she said the juror works at the monkey farm. I was here trying to figure out what juror works at the monkey farm. And this juror number 785 works with, they have the business name redacted, and they say that's the monkey farm. In brackets, there's discussion of what the monkey farm is. The clerk said the juror they were posting about was a juror. The court says that juror 785 who works at the monkey farm and that this email referenced the juror who works at the monkey farm. Counsel Griffin suggested bringing juror 785. The court agreed and noted its desire to also hear from Clerk Hill, who was not present at that time, but had mentioned the Facebook post earlier that day. After some discussions by the parties as to appropriate procedure and the desire of the complainant to remain anonymous, as well as other trial procedural matters, the court conducted an in-camera examination of juror 785 to discuss any conversations that the juror had with anybody about being on jury duty. As part of a brief discussion about the post on Facebook by juror 785's ex-spouse, juror 785 noted that Clerk Hill had alerted her to the alleged post. The court specifically followed up and asked, has the clerk discussed anything about the case with anyone on that jury? The juror says, not that I'm aware of. That's important. Counsel Griffin, then satisfied, accepted juror 785's explanations and argued he or she remained a competent juror. Upon the state's expressed desire to know the identities of the persons who reported the improper contact to the court again summoned juror 785 and elicited additional information sufficient to identify the persons with whom the juror allegedly had the improper conversations. They were two of juror 785's tenants. They referred to them as the male and female tenant. Shortly after 9 p.m. that evening, agents with SLED located them, interviewed them separately, and prepared memoranda and recordings reflecting the interviews. On March 1st, 2023, the 27th day of the trial, the tenants met with the ADAG and executed affidavits consistent with their statements to law enforcement the night before, which stated juror 785 had delivered a refrigerator to them on Saturday, February 18th, 2023, and briefly discussed the case. After the jury view and the state's initial closing, the court convened another in-camera hearing to review the affidavits and examine juror 785's tenants. The court asked male tenant about his affidavit, and male tenant explained he offered his opinion about the case to the juror, who had disclosed their role as a juror while speaking to female tenant while delivering the refrigerator. Juror 785 had replied to male tenant that she hadn't decided either way because it was kind of early in the case, and I guess she had made no decisions if he was guilty or if he wasn't guilty. The state then reviewed with male tenant his affidavit line by line, which he confirmed as accurate. When counsel Harpootlian asked male tenant to elaborate on line 9 of the affidavit, in which male tenant recalled juror 785 stated she didn't believe there was any evidence to make her think the defendant was guilty at that time. Male tenant expressed that he took her to mean she had not made up her mind. The court next examined female tenant. Female tenant explained juror 785 disclosed while delivering the refrigerator that they were on the jury, which prompted male tenant to offer his opinion as to Murdaugh's guilt. Female tenant recalls juror 785 replied, "Well, I can't talk about it." When pressed by counsel Harpootlian, female tenant recalled juror 785 said that she could not without a doubt or whatever say he was guilty. Juror 785 did not explain to female tenant why she held that position. Female tenant reaffirmed her recollection in her affidavit that juror 785 indicated she didn't believe there was evidence beyond the shadow of a doubt or beyond a reasonable doubt that Mr. Murdaugh committed the crimes he is alleged to have committed. After hearing arguments from attorneys for each of the parties, the court noted that in many cases, typically without an inquiry, this juror would be gone without anything further, without any discussion, because she's discussed the case and was ordered not to discuss the case. Even if she discussed it for a very short period of time, she's having a discussion so much that this person understands that it shouldn't have taken place, and sent the email. The court then summoned Clerk Hill to discuss the supposed Facebook post. Clerk Hill explained to the court that she briefly saw a post the preceding Friday on Walterboro word of mouth, which she attributed to a juror's ex-spouse, which said that he noticed his ex-wife was saying she was on the jury and saying stuff about how her verdict was going to be, that he was the ex-husband, but she was known for talking way too much. And then I just kept on scrolling because that was enough for me. I've gotten enough. Clerk Hill figured the post referred to juror 785 and alerted the court after learning the court had received an email the following Monday. When Clerk Hill tried to find a post again at the court's directive, she could not, but found another post by another account with the ex-spouse's name that apologized for deleting a post made while drunk and possessed by Satan. After some discussion about the feasibility of finding the devil-afflicted the devil-afflicted suspected ex-husband, the court asked if the parties wished to locate him. Counsel Harpootlian very clearly declined. Quote, "I think not, Judge. I think if you would just accommodate me, bring juror 785 in and ask them about the specifics of the conversation. If juror 785 says yes, I'll have no complaints whatsoever." End quote. The court complied with Counsel Harpootlian's request, again, summoned juror 785, informed them that the court had met with the tenants and asked if the juror could recall anything further about the conversation. Juror 785 acknowledged delivering the refrigerator and that the tenants had expressed opinions to her about the trial, but denied expressing any of the jurors' thoughts to the tenants. After discussing juror 785's ruse to claim they were in Facebook jail during the trial and irrelevant particulars of their employment, Counsel Harpootlian observed the juror place their spouse at the scene of the conversation. Juror 785 called their spouse, put them on speaker, and upon brief examination by the court, the juror's spouse said the juror was talking with my tenant's girlfriend. And I know they talked about the trial. I don't know to what extent, if you know what I mean. The spouse further explained nobody was saying, guilty or innocent, but they were talking about some of the facts that had come out in the case either way. The spouse also acknowledged talking if there was any excitement in the juror's day each evening, but that they did not talk details. Finally, the court granted Counsel Harpootlian the opportunity to confront juror 785 directly with their tenants' affidavits, which the juror denied as inaccurate. Once juror 785 was excused, and after a very brief discussion of the witnesses, Counsel Harpootlian declared, "I'm not going to argue any more about this. I'm going to defer. It's your call, your judgment. Your Honor, I'm not going to argue with whatever you do, okay?" The following morning, March 2nd, 2023, after reviewing the video recordings of the interviews with the tenants, the court excused juror 785 from service for offering her opinion regarding evidence received up to the point of and during the conversations with the tenants. Counsel Harpootlian affirmatively declined to take any exception to the ruling. Juror 785 was brought to the courtroom, advised of the court's ruling, and upon inquiry about a conversation this morning with Miss Becky, the court emphasized its ruling had nothing to do with anything brought up about the juror's ex-spouse. Juror 785's possessions, to include a dozen eggs, were retrieved from the jury room, and juror 254 was promoted from alternate to the panel. The jury, which never deliberated with juror 785 or alternate juror 741, convicted Murdaugh of killing his wife and son. Upon inquiry by the court, Counsel Harpootlian requested the jury be individually polled. The court so polled, and each individual juror affirmed guilty was their verdict and remained their verdict. Less than 1 week later, attorney Joe McCullough represented to media that juror 785 did not wish to speak publicly about the case and did not wish to be contacted. I love Joe McCullough. He is a hoot and a holler, y'all. And he has great hair. Rachel Sharp, infamous egg juror in Alex Murdaugh's murder trial, asked to be left alone. That was from The Independent on March 8th of 2023. At some point unknown to the state, McCullough also assumed representation of juror 630 and so represents each of the jurors who have provided affidavits to Murdaugh. They move on to the state's motion to strike. In support of his motion, Murdaugh provides various affidavits which are deficient under the South Carolina rules of evidence. Notwithstanding any effort by the state to grapple with the affidavits in its arguments in sections 4 and 5 below, the state must respectfully move to strike portions of Murdaugh's motion for a new trial as follows. The state moves to strike as inadmissible hearsay the affidavits of paralegal Holly Miller. In support of his motion, Murdaugh provides 2 affidavits from Counsel Harpootlian's paralegal Holly Miller, which largely purport to reflect statements made to or otherwise in her presence by 2 jurors, 741 and 326. Hearsay is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Hearsay is not admissible. An affidavit from Miller is not a tantamount to an affidavit from the juror themselves and constitutes textbook hearsay. Accordingly, the state moves to strike in part as inadmissible hearsay motion for a new trial Exhibit B at lines 4 through 11, Exhibit J at lines 2 through 9 and any such part of the motion that relies thereon. I'll link those. You can go look up those lines if you want. The state moves to strike as inadmissible under Rule 606B all such material as regards internal functions and deliberations of the jury. In support of his motion, Murdaugh provides 4 affidavits which purport to reflect statements made by jurors which, in part, pertain only to juror mental processes and interactions with one another. As previously noted, jurors may neither testify nor may the court accept affidavits which pertain to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or another juror's mind or emotions, excepting claims of outside influence or extraneous outside information. It says, denying without a hearing a defendant's motion for a new trial and refusing requested inquiries as prohibited by Rule 606B because they would cause jurors to reveal the subject matter of their deliberations. Remarks in the affidavits regarding jurors' thoughts about the evidence or one another are not properly admissible or even relevant to the ultimate claim raised. Accordingly, the state moves to strike in part as improper juror testimony, motion for a new trial. They list some exhibits and the lines thereon as any such part of the motion that lies thereon. The state moves to strike all such material as regards Murdaugh's claims regarding the Facebook posts, book deal, and post-trial media interactions as immaterial, impertinent, and scandalous. The greater part of Murdaugh's motion is dedicated to an outlandish theory that Clerk Hill deliberately fabricated the existence of a Facebook post implicating juror 785 in order to get them removed from the jury, force an outcome, and thereby profit from fame and fortune. To be clear, in an attached affidavit, Clerk Hill affirms she made no such deliberate fabrication, and she denies fabricating any Facebook post. Indeed, the allegations do not even begin to make sense. Under Murdaugh's theory, Clerk Hill heard the court had received an email which implicated a specific juror. Then in immediate response on the fly, reported a fictitious Facebook post to implicate that same juror. Then conspired with another staffer to quickly and by sheer coincidence be lucky enough to find an apologetic post by someone with the same name as the juror's spouse, which she then reported to the court in an effort to get an uncertain juror removed so as to ensure some outcome that would support a book deal she did not have at the time. Only Alex Murdaugh could conceive of such a confounded gambit as even remotely plausible, and he is projecting his own calculating, manipulative psyche onto a dedicated public servant in an effort to save himself. Whew, they did not mince words there, did they, y'all? Strategically, Murdaugh's inclusion of the Facebook post narrative appears to be a desperate effort by Murdaugh to preemptively impeach Clerk Hill, to bring into dispute irrelevant facts in order to support his petition for a writ of prohibition pending in the Supreme Court of South Carolina, and to beef up what would otherwise be a thin, blandly legal filing not likely to draw attention to the various media efforts of his legal team. Whatever Murdaugh's motivation, the court expressly did not rely on the alleged Facebook posts in removing juror 785. Therefore, whether Clerk Hill saw the alleged post, is mistaken as to the alleged post, or even fabricated it is of no consequence to the validity of Murdaugh's conviction or the actual claim raised by Murdaugh of improper external influence upon the jury. Accordingly, the state moves to strike entirely motion for a new trial. They list some exhibits and any such part of the motion that relies thereon. Argument 1, even assuming that all facts in Murdaugh's motion are true, the motion fails to make a showing that he is entitled to an evidentiary hearing or relief. Although Murdaugh's motion for a new trial makes various allegations as part of its attempt to craft a breathtaking conspiracy narrative, it ultimately boils down to a single constitutional allegation. Clerk Hill told jurors, "Do not believe defendant," thereby violating his right to an impartial jury. Accordingly, even if the state assumes that all of the component elements of the affidavits provided are earnestly given, the relevant analysis is as demonstrated by the questioning in State versus Green. Number 1, was the juror's verdict guilty? Number 2, was the juror's verdict based on the evidence presented? Number 3, was the juror's verdict influenced by the alleged outside communication? Number 4, did the juror have any communications about the case outside of deliberations with the jury? All of the other details are irrelevant window dressing. One juror who participated in deliberations, Juror 630, ties to Clerk Hill any statements remotely consistent with Murdaugh's allegations of improper external influence. Do not be fooled. Watch him closely, look at his actions, and look at his movements. Even assuming for the sake of argument that Juror 630's recollection is accurate and that he or she are not misremembering arguments expressly made by the state, Juror 630 does not attribute their verdict to the statements of Clerk Hill, but rather that he or she voted guilty despite some questions because Juror 630 felt pressured by other jurors. That juror felt pressured by other jurors is not a valid basis to impeach a verdict. Nor does Juror 630's complaint of feeling pressured by other jurors constitute evidence that he or she or any other juror voted to convict because they were influenced by comments they allegedly heard from Clerk Hill. Murdaugh offers an affidavit which purports to represent statements made by Juror 326, although the affidavit is that of Counsel Harpootlian's paralegal, Holly Miller. Even if the state accepts that Miller's affidavit is the equivalent of an affidavit from Juror 326 themselves, it is unavailing to Murdaugh. Juror 326 contradicts Juror 630 and recalled no such comments by Clerk Hill regarding Murdaugh's credibility. What Juror 326 did recall was a warning that the jurors would witness disturbing images, which is a neutral trigger warning and not one which puts a thumb on the scales of justice. To be sure, the jurors did review disturbing images. No affidavit attached to Murdaugh's motion from or about a deliberating juror shows any effect on the verdict, even including Juror 630. Nothing else offered by Murdaugh helps meet his burden of making a showing. Neither Juror 785 nor Juror 741 participated in deliberations and thus cannot aver that their deliberations were influenced. Absent any representation that a deliberative juror's decision that Murdaugh was guilty was actually influenced by the improper communications alleged, Murdaugh has failed to make the showing necessary to justify so much as an evidentiary hearing, let alone a new trial. Accordingly, Murdaugh's motion for a new trial should be denied. Argument 2, should the court deem an evidentiary hearing necessary, the state expects the material allegations will be shown to be not credible. In the alternative, in the event the court concludes Murdaugh has made a showing sufficient an evidentiary hearing in this matter, the state expects that sworn testimony to the court will prove the allegations to be unfounded and not credible. Since Murdaugh's filing in the South Carolina Court of Appeals, agents with SLED have successfully interviewed most of the jurors and the final alternate juror. One juror declined to discuss the case or deliberations. That was Juror 578. And 2 jurors are represented by attorney Joe McCullough. That's Jurors 630, Juror 785, who at the time of this writing has yet to consent to an unconditional interview with his clients. Clerk Hill denies commenting to the jury regarding Murdaugh's defense or testimony. Upon information and belief, SLED's investigation into the allegations of jury tampering produced the following answers from the jurors who deliberated. I'm going to go down this list. We're going to do one at a time. It's going to tell the juror number and this, did they hear remarks on evidence by Clerk Hill? Juror 193, no, maybe generally pay attention. Juror 254, watch Murdaugh's body language. Juror 326, no, gave a graphic material warning. Juror 530 said no about hearing any remarks on evidence. Juror 544, no, generally pay attention, look at body language, and be observant. Juror 572 and 589 both said no. Juror 578 declined to discuss the case or the deliberations. There was no interview from Juror 630 at the time of this filing. Juror 729 said no, generally just pay attention, heard no body language comments either. Jurors 826 and 864 both also said no, they did not hear any remarks on evidence by Clerk Hill. The next thing that's on this chart, Did they see any one-on-one chats by Clerk Hill with jurors? 193 and 254 both say no. Juror 530 says no. Juror 544 says no. Juror 572 says no. Juror 589 says no. Juror 826 and 864 say no. The ones that say yes, Juror 326 saw a chat regarding financial and child support. Juror 729, yes, they had a chat regarding financial and child support and saw the clerk chat with others. Juror 578 wouldn't discuss the case or deliberations, and 630 had not given an interview at the time of this filing. When asked, were there any other concerns? Jurors 254, 326, and 530, as well as 572 and 826 said no. Other concerns, Juror 193 said, if anything, people were overly cautious. Juror 544 said Juror 630 is a tenant of Juror 785 who is upset. They also say they were warned by Harpootlian of a subpoena if they did not talk. That's Juror 544. Juror 589 says spouse warned by Harpootlian of a subpoena if they did not talk. Juror 729 denied statements regarding them in the affidavit of Juror 785. Uncomfortable when Harpootlian waved the gun around. And Juror 864 said it was Creighton Waters in court who told the jury to watch body language. You see the common theme there. There's nothing there among any of these jurors who spoke, who said absolutely saw inappropriate stuff happening with Clerk Hill. Exhibit B is the redacted written statements of jurors. Perhaps most importantly, none of the jurors who willingly interviewed with SLED reported feeling any pressure or influence to reach the verdict. Jury coordinator Willard Polk Jr. reported that he was the interface between the jurors and the court and did not hear Clerk Hill or any other person attempt to influence the jurors. No other court staff witnessed any external influence on the jury either. Altogether, the allegations raised in the affidavits provided by Murdaugh can be explained as a combination of simple mistakes and, unfortunately, a non-credible affiant. They say here that Juror 630 and Juror 864 both noted that it was more leaning towards they heard this stuff from the state and not Becky Hill. The state argued to the jury to not be fooled by Murdaugh. The state advised the jury to watch Murdaugh closely in the context of his video recorded statements, and the state emphasized the importance of body language. Juror 785, purportedly the landlord to Juror 630, was removed from the jury after the court determined she talked about the case improperly with the tenants. Juror 785 only recalled the fooled by language, which was actually articulated by the state in its closings the day before Juror 785 was dismissed. But most importantly, the court specifically asked Juror 785 during the in-camera hearings if Clerk Hill had discussed the case with her or any other jurors to her knowledge. Juror 785 replied, "Not that I'm aware of." Mic drop. It strains credulity to believe that Juror 785 would not be aware of Clerk Hill's supposed statements when specifically asked by the court at a time proximate to when they were allegedly made, but would suddenly recall them many months later after learning Clerk Hill published a book. The remainder of Juror 785's affidavit reports incredible one-on-one conversations with Clerk Hill, which, aside from Juror 785's inconsistent but more credible denial to the court, pertain only to the wholly irrelevant Facebook post. Finally, contrary to Juror 785's affidavit in support of the motion for a new trial, the tenants of Juror 785 affirmed the statements they made in their affidavits at trial and in-camera testimony. Alternate Juror 741 would not sign an affidavit as requested by Murdaugh's counsel and was evidently reluctant to do so. Juror 741 told SLED investigators that Clerk Hill told the jurors that the defense is about to do their side and don't let them confuse or convince you. They may say things to confuse you. However, neither Juror 630 nor Juror 785 clearly corroborate Juror 741's recollection, and no other juror even comes close to doing so. Juror 741 told SLED she was aware that Clerk Hill wrote critically of her attentiveness during trial and additionally noted that Clerk Hill told her after trial that no members of the media wished to speak with her. So this is the juror, I believe, that would lay back, stuff tissue in her ear. And honestly, I was surprised she was allowed to stay on because every day it kind of seemed like some new antic with her. The greater weight of anticipated juror and court staff testimony is that Clerk Hill made no materially inappropriate comments. The state denies Murdaugh is entitled to relief and anticipates that any evidentiary hearing will only reaffirm the validity of his conviction for the murders of Maggie and Paul Murdaugh. Furthermore, even if Clerk Hill made any improper comments to the jury, the state has found no jury who will agree that anything Clerk Hill said or did influenced their verdict. The court clearly instructed jurors to only consider the competent evidence presented to them and to apply the law as the court gives it to them. The jury presumptively and affirmatively did so. Each individual juror reaffirmed their verdict when polled by the court, and none reported any influence from any court staff. The court's instructions to consider only the competent evidence and individual polling procedure after the verdict was returned served to disabuse jurors of any misconceptions which may have developed over the weeks-long trial and cure any errors which may have otherwise resulted. So the conclusion is the state respectfully requests this court deny Murdaugh's motion for a new trial. Barring that, convene an evidentiary hearing consistent with that concluded in the State versus Green. Upon hearing the testimony of the jurors and witnesses presented, find Murdaugh's allegations to be not credible and denies motion for a new trial. Below that, they have some handwritten statements of jurors. This first one is from SLED. The juror says they were not coerced into giving a guilty verdict. I came to the decision at my own free will. I did not feel anything was said to influence my decision-making. I did not witness any private conversations pertaining to the trial and was not approached by anyone. I did not witness any jurors speak privately about the trial. I did not feel pressured to come to a quick verdict or that I was required to reach a verdict in a certain time frame. I have not spoken to the defense team. To my knowledge, no juror attempted to begin deliberations early. Juror 254's voluntary statement to SLED. This was my first time as a juror, and I found this experience was very rewarding as a civic duty. During the time, we as a jury were treated with respect and received anything we requested. The only time that I had interactions with anyone was through the bailiff. Other than one time when we as a jury were waiting to go into the courtroom and a comment was made to watch his body language. At that time, I didn't take it any way other than to watch his body language. That comment didn't persuade me of the decision that I ultimately made during deliberations. Juror 326 voluntary statement to SLED. I believe that my interactions with Ms. Hill, the court clerk, was limited to information from the judge or about important events such as graphic material or how long of a break we would get. I do not believe she acted outside of her role as court clerk and acted in a very professional manner. Juror 530's voluntary statement to SLED. I did not at any point feel pressured to make a decision throughout the trial, nor did anyone attempt to sway my decision by any means of communication. At no point in time throughout the trial did anyone attempt to have a one-on-one conversation with me for any purpose regarding the trial. To the best of my knowledge, there was no court official or employee that questioned myself or other jurors regarding the trial or its outcome. To this date, I have not been contacted by the defense regarding the new allegations or other topics. Throughout the trial, I did not observe anything that I perceived to be unethical by any court employee. Juror 544's voluntary statement to SLED. While on the jury, Ms. Hill never made me feel as though she was trying to sway me either way, innocent or guilty. Ms. Hill spoke to us as a group in regards to what type of things we would like for snacks, breakfast, and lunch. Ms. Hill mentioned if we were sequestered, we would be staying at a hotel and we would be given time to gather our things to stay at the hotel. She also stated that an agent or officer would be with us the entire time. I felt she stated this to us as trying to keep us informed of what may or could happen. I was never made to feel pressured to say or do anything by anyone, court employees, or co-jurors. I never witnessed any jurors going into a room alone with Ms. Hill. Another voluntary statement by Juror 572 to SLED. No, I was not coerced into giving any answers. My decision was of my own. No court employee influenced my decision. I did not have private conversations other than myself talking to Miss Becky Hill about me not using the stairs because of my knee injury. I did not witness any private conversation amongst the other jurors. I did not hear or witness anyone or any court official stating to us jurors that we should not listen to the witness or it shouldn't take long, etc. No one made me feel that I had to arrive to a quick verdict, and if I didn't, myself or the jurors would not be able to leave. No one from the defense team ever reached out to me pertaining to the Murdaugh trial. The juror that was ejected from the trial stated one morning on the van that her husband told her we were going to Moselle, and we told her no discussions. Another voluntary statement by juror 589 to SLED. It says, I was a member of the jury. When we would go back to the jury room, most of them stayed in the same room from the beginning. Miss Hill would come in periodically to see if we needed anything and check on us. I did not feel rushed at any point to make any decisions. Did Miss Hill ask questions about your opinion? No. Did Miss Hill pressure you to speak to, and then it's redacted. I felt no pressure to speak. I had made my mind up. Juror 729's voluntary statement to SLED. During a 6-week trial, I found that with 2 different rooms, there would be a lot of gossip between strangers. Each room was filled with men and women. The room I was in was a quiet room, while the other room was louder and filled with conversations of work and private life. I spoke with Becky Hill on a couple of occasions about my financial burden and that I needed to speak with the judge. Smoke breaks once a day, sometimes more. She did come speak to others, but I didn't hear the conversations. During the trial, I had a very uncomfortable feeling as the defense attorney would wave the gun around as if he had never held one before. During our smoke breaks, we would talk about lunch or what we were missing at work. There was always something to talk about or someone to talk to. After 6 weeks, it came time for deliberation. Everyone took an anonymous vote, followed by an open discussion and questions. It was fast and smooth, but I felt no pressure. I was set in my decision. After everyone discussed our thoughts, we voted again. Every vote came back guilty. We checked multiple times to see if all were comfortable with the decision. If we needed to wait, we would have. On the day of sentencing, we were approached by Dateline and Miss Hill, who asked if we wanted to go do an interview. We told her no. She seemed disappointed, but let it go. Did you ever hear anyone tell the jury not to be misled or fooled by evidence presented in Mr. Murdaugh's defense? She said no. Did Miss Hill ever ask your opinion in regards to the trial? No. I did not have conversations with Miss Hill like that during the trial. Did you ever feel pressured to make decisions prior to deliberations? And she said no. Juror 826, voluntary statement to SLED. Did you feel at any point during the trial pressure to make a decision? No. Did any court official or court employee persuade you or any other juror one way or another as it pertains to guilt or innocence? No. Did any court official or court employee have a one-on-one conversation with you or any of the jurors? No. Did anyone attempt to contact you after the trial regarding the trial? No, except for the media. Did you feel anything during the trial that you perceived to be inappropriate or unethical? Not that I recall. Did any court official or court employee question you or any juror prior to deliberations about decisions of the jurors regarding guilt or innocence of the defendant? Not that I'm aware of. Voluntary statement by juror 864 to SLED. No one pressured me to make my decisions of guilty. No one influenced me to make any decision or said anything to cause me to come to a guilty verdict. This juror did not see any private conversations taking place. He was not told he would not be able to leave if he didn't make a decision. No one from the defense ever called or came by my house. I did hear someone say, we are going to Moselle. They go through court staff. They pretty much give the same statements, essentially, that they did not see or hear anything that would be perceived as jury tampering. So that's kind of long and it can get monotonous reading that, but this is a case that we have followed very closely. So I wanted to read that pretty much in its entirety. I left some things out, but there you go. So it's going to be interesting to see what happens next. So if you've got 2 jurors here that were not model jurors who have a bone to pick with Becky Hill, and then you put that against all of these other jurors who voluntarily gave statements to SLED, where does this go? I don't know. Maybe everybody's brought in and they're asked under oath, did you hear or see anything? But I don't know. It kind of seems like a nothing burger to me, but I'm not an attorney and I'm not a judge. So that's just my views on this if I'm looking from the outside. So, what do you guys think? Let me know in the comments. That's why I wanted to read all of this. Was there anything in there that was a red flag? I thought it was also very solid that some of the things that these jurors are saying was said by Becky Hill were actually said by the defense. Anyways, that's it. Another episode coming out later today for day 5 of testimony in the Caitlin Armstrong murder trial. So look for that later this evening. In the meantime, hope you have a good rest of the day. We'll see you soon.